The CPI report, Child Protection in Iowa, is brought to you by Vocal Victims of Child Abuse Laws. You can watch our program all on Channel 15 here in Des Moines, Iowa. The time on Sunday is 1 o'clock p.m. On Wednesday, it is 9:30 p.m. And those who are living in Council Bluffs, Omaha, can watch it on Cox Channel 23. In this case, our program is aired every other Thursday at 4:30 p.m. You can email us at vocaliowa@mchsi.com. My number in Des Moines is 515-276-3956. John's number is 515-282-2672.
They're calling already.
We're here to help parents, so if parents have a problem with the DHS, they can give us a call and we'll give you our opinion that from our experience we've experienced these things for close to 20 years for each one of us. So if you want some encouragement, advice on what we could help you with as far as DHS getting through the court system, give us a call. My name is Don Burgmaier, and with me at the controls is my co-host,
John Harvey, and welcome to the CPI report. That's Child Protection in Iowa. We attempt to perform two things. One is to influence public policy as it relates to child protection issues, and secondly, we attempt to assist people who are having difficulties with the Department of Human Services. That is a rather difficult but a very important task that we attempt to accomplish. So we have those two major issues: influence public policy and to assist in whatever way we can. We're not attorneys. We don't hold ourselves out to be attorneys, but we're individuals who have been there once or twice, and we can give you some kind of a hint as to how to view your own problems. We can't do the work for you because that would really be intensive, but we can give you some hints as to where you can look and where you can go to get additional references that would help you. One of the problems that I have seen is the problems that we create for ourselves. And one of those problems, and I think the Department of Human Services is going to be around long enough to pick up the pieces. They love to see Humpty Dumpty fall off the wall. And one of the things that we've mentioned in times past is this decline of the nuclear family, where we have a mom and a pop, have big brother and little sister, Puff and Spot, the little animals, and one big happy family. When that family parts or is separated or something, things happen that attract the Department of Human Services, much like my nephew says, like an outhouse attracts flies, and they will hover around your unit until they nab you one way or another. And one thing they love to do is to remove your children. It has a tendency to get your attention when they do that, and and with your attention, they can make you jump all kinds of hoops in order to somehow protect your family.
is it to the parents' benefit to jump through the hoops that DHS offer?
It may be, but I've never seen it happen that it benefits going to get parenting training or getting training in finances, or they don't really care what it is, as long as they are able to dish out what they call services. But the services don't have to be connected in any way to whatever it is that you may need for service. purposes. I want to make a few remarks, and then we're going to talk to a fellow by the name of Terrance Walker. But in the meantime, I'll make a few comments and follow up of what we've done in times past here, and I hope to add a few of these problems, illustrate some of these problems as we go. We have now a drug problem, which is an enormous problem to add to the one that I was talking about a moment ago, and that is the breakdown of the family. Wherever there's drugs, there's going to be a social worker sniffing, snooping, and intimidating you to get what they call a UA, urinalysis. And they'll say, well, if you've never used drugs, all you have to do is get a urinalysis, and they indicate that that's going to satisfy them. Well, once you get your urinalysis, they'll find something wrong with it, and bang, you're in court, and you've lost your children to court supervision. These courts, once they get your child in what they call a China, under a China petition, they become the new parents of your children until such time as they feel that those children can be dispatched either back to your home or into foster care and eventually into adoption. The incentives are great for them to put children in foster care. They can wield a lot more authority, a lot more influence over the children and over your family if they're able to get them out of your immediate care. And I have found out in recent days that there is something called supervised visitation, in which you pay through the nose. And I thought it was something like $18 an hour, but I've been informed that that can be $45 an hour. When I mentioned the figure 45, someone said, no, that can run up to as high as 60. And when I mentioned it to a gentleman this morning, he said, no, they can charge as much as $75 an hour for you to visit your own children. So we have a sub-industry inside of the child abuse industry that is making a fortune just to sit there and watch mom or dad or both of them visit their children. So if you get 2 hours a week at $75 an hour, there goes all your gas money for the week. $150 just to see your children. How ridiculous are we becoming that we permit these kinds of agencies to foster this kind of nonsense?
It's called intimidation.
It certainly is. A plain reading of the statutes gives the appearance that the Department of Human Services is formed to be a service agency offering services directly to families in such a way as to help families in need. The motto is Iowans working together, doing what works. Careful observations of the actions of the agency shows a completely differing perspective. The DHS hired an individual whose only task is to write grants for DHS. It's the money-making scheme, remember. The name of the game is how much can the department acquire through various kinds of financing. See, they should be depending upon the legislature to fund them for the important part of what they're supposed to do. And then they should be tied on accountability standards to the legislature and their funding cut when they do not meet their accountability standards. But that isn't the way we work here. We just go to the legislature for enough money to get a staff going, and then you hire other people to find all kinds of funding sources, and then you do what you darn well please. And if the legislature wants to peek into what you're doing in the DHS, sorry, buddy, we're on our own. We can run this agency without your help. Even worse than the pursuits of grants is the fact that the department fully intends to snatch money from whatever source it can find it, even if they sell out, even if the sellout bargaining turns out to be counterproductive to their stated mission and counter to Iowa families. In other words, if it's more lucrative to remove children and put them on the market rather than to return them to their families, DHS will gladly do whatever it takes to maximize its income and influence. Social investigators have become very clever in their data gathering and reporting so as to slant the rulings to reflect what DHS wants the courts to do. So they can lie through their teeth, and since they're a public agency, authorized public agency, the judges are more than likely to believe them. The worker said that it is suggested that the family home was a drug trader because there were many cars in the street when she visited. Many cars in the street, therefore it's a drug house. No, there's probably many cars in the street. It's because people live there and they leave and they park their cars in the street.
Some people work at night, so
Sure.
they park their car during the day on the street.
You bet. While the statement was not a direct lie, it was fully and willfully constructed to imply an untruth.
What about the DHS worker's car that was parked on the street? Somebody could come down the street and see that car and knew that was a drug car.
Sure, by all means. Well, of course, if it has a state emblem on it,
And then it's a sure thing.
that's right.
It's a proven fact that they push the most drugs on kids of anybody gone.
That is true.
Especially Ritalin, huh?
That's right. You bet.
Well, they'll even pump 9 or 10 drugs together, or maybe more, onto a kid.
Sure.
It's a wonder they survive.
Until they age out of the system, and then they're on their own.
And
to
then
go
they're
get
druggies, and then they go out and get drugs just because they're hooked on it.
Often we hear families saying that the agency is the Department of Inhuman Services. These comments come from those who have had, at one time or another, been clients to DHS. So it isn't something that I have used that they've picked up. It's something that they bring to me without me even suggesting that this is a Department of Inhuman Services. Whenever the department finds that it can attract another government grant or extract money from some other pipeline, it will abandon its original intent and grab the cash without regard to what happens to the family. In other words, the funding is more important than their fiduciary responsibility to care for the children. There are a number of reasons to believe that the current decline in the system is well ingrained and most likely to be perpetuated. Much of the problem arises from government funding initiatives which are counterproductive to the intact family. We have mentioned a couple of ways in our society that our society aids the DHS and actually issues an open invitation to intervene in the family. Two of those ways. Number one, the breakdown of the family. Until we get that straightened out, we're going to have hordes of social workers hanging around seeing where they can impact our family. Number two, drugs. And it seems as though Iowa has become the meth drug capital of the nation. And it's unfortunate that people are using drugs. However, I should point out at this point one method for defense. Remember that they must show, these supervisors that come into your home must show that there is some direct connection between the parents' use of drugs and some harm done to the children. Now, they may lie their way through it, but remember, if you're there, you can tell the court wherein they are telling the truth and wherein they are lying. And don't leave it up to the Department of Human Services to have the only story when it comes time to for the removal hearing, the dispositional hearing, the adjudicatory hearing, the placement hearings and whatever other hearings you have that crowd our courtrooms and cause us to have to hire more and more judges who then beg for more and more courtrooms.
And more pay raises.
and more pay raises. But,
well, actually, they don't beg for pay raises. They beg for more money, and then they give themselves pay raises.
That's right.
That's what happened
this last time around.
Last time around, that's the way it usually works, isn't it?
It was the ultimate bait and switch.
That's right. So I want to mention another way that if you really want the Department of Human Services to be in attendance, to watch over your family and to care for them and to snoop whenever you're not looking. This is one good way of getting attention. That is, send your children to the public school. Now, what will happen to your child at the public school? Because a lot of the people I'm talking to right now are sending children to public schools. There's something in the public school called the guidance counselor. The guidance counselor will come with marvelous stories and a very compassionate approach to children. Sometimes the children do not go to see the guidance counselor like they're supposed to. So the guidance counselor will set up appointments to demand that each child come to the guidance office to talk to the guidance counselor. If you're a parent, I would say, I would alert the school that there is to be no contact between your child and the guidance counselor. Knock it off entirely. Now, the guidance counselor comes to your child's classroom and talks to your child about all kinds of child abuse, and and the guidance counselor can tell your child that if a mother or father raises his voice, that's emotional abuse, and you should come and tell your teacher or your friendly guidance counselor that has happened, and the guidance counselor will report that. So you can have the upper hand. All you have to do is come and talk to the guidance counselor. Now, here's one of the legal problems that arises from that. The guidance counselor cannot share with you as a parent what the child says to the guidance counselor by law. Cannot share that information because that is part of the law under which the guidance counselors operate. They cannot share that information. So they're like a father confessor or a priest in which the child can confess all of his problems to the guidance counselor. The guidance counselor has to keep quiet about it.
Unless they talk to DHS.
Except the guidance counselor is also required to report everything that your child says to the guidance counselor. They're required to report that to the Department of Human Services.
I was right.
So, absolutely. They've got you in a real bind. One other thing before we
and you don't even know you're in a bind.
not until it's too late, and
After they terminate your rights, then you begin to think a little bit.
Right. Okay. Now, one other thing I should mention just in passing here, because there's a dozen other ways that you can draw attention to yourself. One way that you can surely draw attention to yourself, and you may not want to take my advice on this, that is, don't spank your children in public. If you're going to spank your child, make it a private affair. This will draw attention like nothing else. And even if those compassionate people at your church even see you spanking your child or hear of you spanking your child in church, someone at that church may be so compassionate about your family, they can report you. It's been done before. So beware. There are ways in which you can draw attention to you can draw the DHS's attention to your house. Now, maybe you want to do that. If you want to do that, I have 18 other ways in which you can also send up red flags There's many different ways in which you can draw attention. And one of the real problems, and we'll probably talk about this too, it has to do with the decline of the family, but it's when child abuse charges are lodged back and forth in a custody issue. Uh, the Department of Human Services loves this kind of situation. So that is my sermon for this time around. We'll expand that beyond our 3 points here. And in the meantime, we're ready to talk to someone who has done a lot of work looking over courtroom matters. And there's a reason why we take an interest in what happens to the courts, because until such time that the courts are straightened out, until the time they get their act together, until their time that there is some honesty and integrity in the court system, and some rationale for the way they operate, and some respect for the rule of law, we will not survive as a civil society. And anything that we attempt to improve in the child abuse area will be for naught until the courts are there ready to back us up. In the meantime, we're in trouble with the courts. And if you don't believe it, let's turn to this fellow. He might be able to convince you further. Terrance Walker.
Well, thanks a lot, John and Don, for having me on the show again. Yes, we are in trouble here because as a wise old friend told me a long time ago, you have no rights. And I didn't really understand the full import of what he was saying until years later, because I had been raised, as we all are here in the United States, to believe that we have the Bill of Rights. We have the First Amendment, Second Amendment, Fourth Amendment. We've got all these amendments protecting us. Yet and still, if no one is enforcing them, that is, for example, a judge or a court, then you do not have any rights. And it's so important, which is why I religiously watch what happens in the courts here in the state and throughout the United States as much as I can, and I think everyone should. It's so important because the courts have a say-so over your rights as your property, your liberty, even a lot of instances your protected or your liberty interest in your children, your right to have your children. You know, we see a lot of cases here in the state of Iowa going to the Iowa Supreme Court, Iowa Court of Appeals, about 20, 30 cases a month, where they're actually reviewing termination of parental rights on a monthly basis. So lot at stake when it comes to cases coming before courts. And one of the main problems that we have with our court system is the fact that judges are immune from lawsuits. They are immune and unaccountable. They do have these commissions, judicial qualification commissions. Most states do for their state courts, and most federal courts do. They have a federal commission to investigate complaints on judges. Most of these complaints, in a lot of instances, over 90% of the complaints are outright dismissed. And on the boards of these commissions, guess who? Friends of the judges. So we have a system where a case of the fox guarding the hen house, so to speak. So you don't have any sort of accountability there. Can't sue them, can't complain them. So that makes a judge empowered to do what he wants to do, and or she, for that instance. There are a lot of female judges out there. But you know, we tend to think, and a lot of times, journalists even think that judges are somehow like high priests. They're gods coming descending their opinions out of the heavens to us lowly human beings, us lowly citizens. We're supposed to just accept their wonderful opinions handed down because they're ordained by a higher power. That's so far from the truth. These people are everyday people just like you and I. There's nothing holy about them, even though they have the ceremonial uh, things that they do when they come into the courtroom. Everybody has to stand up. Everybody has to be at attention. You may be seated when they say you can be seated. They sometimes they start the Iowa Supreme Court out with the hear ye, all this pomp and circumstance. But you know, to me, it's just a bunch of baloney because these people are just like you and I. We're all red-blooded, tax-paying Americans for the most part, tax-paying. Um, some people don't pay tax. I don't want to mention any names. But that's beside the point. We are all human beings. That's the main point that I wanted to make. And we all are supposed to be, according to the, what is it, the preamble of the Constitution, we have inalienable rights. Is that what's in the preamble?
That's correct.
Okay, just wanted to make sure I was correct.
What does that word mean?
Alienable. That means you can't just say, well, you don't have them rights because you're not from here, or you don't have these rights because you're not from this country. We've got natural rights. Now those rights.
What it means is technically it means there are rights that for which you cannot on which you cannot place a lien. So that makes them unalienable.
Inalienable. I mean, that's natural. Without even someone articulating a law, writing a law down, we have a right. But as I was saying, a wise old man told me several years ago, you have no rights. And I understand his point. Well, to get to the point of my story here, I've got an issue here, or a story here from South Dakota. A fellow by the name of Bill Stegmaier, who is with the Judicial Accountability Initiative. He's for the Judicial Accountability Initiative law, which is an effort which has been spearheaded by the guy by the name of Ron Branson out of Missouri. Several years ago, about 10 years ago to be correct, he wrote the Judicial Accountability Initiative law to be passed state by state so that we can have some judicial accountability and so that we can have a system of review for judges. So I have to applaud him on his efforts. I've been following Ron Branson's activities here for some time, a couple years, and I think they're making some headway. Well, the largest leader up in South Dakota had a problem with the Judicial Accountability Initiative law, and the Argus Leader, which is a South Dakota paper, in their columnists on their board are much like a lot of the columnists on the editorial board here at the Des Moines Register, in that everything that the judiciary does is seem to be benevolent, descending from the heavens on us lowly human beings. They just bestow these high opinions on us, and they're just so above any sort of criticism or critique. But anyway, this David Krantz of the Argus Leader, on August 28th, he writes, and I'll paraphrase here for brevity, a judge could go to jail for handing down a court ruling in South Dakota that someone disagreed with if an effort is successful to put the Judicial Accountability Initiative law on the ballot. Bill Stegmaier, a tea manufacturing company owner, is heading up the effort with support from people around the country. At the center of their concern is a feeling that judges think that they rise above the law and that what their initiative's backers call a self-made doctrine of judicial immunity. So his group of 30 volunteers, South Dakotans for Judicial Accountability, is circulating petitions around the state for from the Sioux Empire Fair to the Sturgis Bike Rally. They need 33,456 signatures by November 7th to be on the ballot. And Stegmaier estimates that his group has already gathered 10,000 names. And he admits there isn't much yet a problem with the issue of judicial accountability in South Dakota. And he quotes Stegmaier as saying, "We are not known for judicial corruption that I know of. It's not a big problem like it is in states like California or Mississippi."
Let's keep it that way then.
But he says that doesn't mean the initiative isn't necessary. So he explains the law. As an example, you go to court, you're the defendant, you want to enter evidence and help your case, and the judge won't allow it. You appeal the case and you lose on the ground you think the judge acts improperly. The appellate court denies your case and you file it with a special grand jury, Stegmaier said. That grand jury, selected from a pool of registered voters through the Secretary of State's office, would be seated. They hear the complaint. They rule whether the judge should enjoy immunity from lawsuits. If they find for you, the next step is to sue the judge. If they deny you, that's it, Stegmaier says. Well, he quotes this article writer, David Krantz, from the Argus Reader, also quotes a judge here, George West, a retired Supreme Court justice from Mitchell, South Dakota. That is one of the nuttiest things I've ever heard. Of course, this is not believable. Not hard to believe coming from a judge. People already have the power. They elect the judges, and if they don't like them, they can throw them out. Good idea, says David Unruh, a Sioux Falls chiropractor who supports the initiative. I think judges all over the country are getting out of control. Our forefathers devised a system of checks and balances, but never for judges doing what they are doing, reinterpreting the Constitution and undermining the people. He says judges don't have the power to override the vote of all the people in the country. So, with that, I would like to go back to the statement that David Krantz said in his article, in the beginning of the article. He said a judge could go to jail for handing down a court ruling in South Dakota that someone disagreed with. Well, to make a long story short, David Krantz got it wrong. We're well aware of the I am well aware of the Judicial Accountability Initiative law. And as Ron Branson points out in his response to David Krantz here, which was sent out August 30th, and I'll quote him, around 1999, an attorney for the appellate judges in California wrote to me with a similar argument. He attacked me saying, I have read your entire initiative, and I ask you, why is it that you wish to take down a judge merely because he makes a mistake? Just as your point, I loved his criticism. I told him that he was indicative of the very reason we need to pass a jail. I told him that he was just like the judges he advises, for he cannot deal with the real issue before him. I told him that if he had truly read the entire initiative, as he says he did, then how could he have missed paragraph 2, in which the South Dakota initiative says, no immunity shall extend to any judge of this state for any deliberate violation of the law, fraud or conspiracy, intentional violation of due process of law, deliberate disregard of material facts, judicial acts without jurisdiction, blocking of a lawful conclusion of a case, or any deliberate violation of the constitutions of South Dakota or the United States. I asked him to point out which phrase he referred to in stating that I was just going after judges for merely making a mistake. And I think his point is well taken, because you cannot say that those words convey the same meaning as merely making a mistake or for having an opinion that was disagreeable. Did you have any comment on that, John?
I think that it would behoove the judge to behave himself at least and to guard against making willful mistakes. Sure, judges and judges should be cloaked with some degree of immunity, and they should be cloaked with a good deal of respect for the way they conduct themselves. But when they fail in their duties to conduct themselves properly, there should be the same kind of judgment that would befall them if they were just an ordinary creature like the rest of us.
Well, and I think that the common response that we get from these judicial commissions is that, oh, the judge just, we can't do anything if a judge made a mistake, or if you just disagree with the opinion. Well, this Judicial Accountability Initiative law does not say that verbiage. It says for deliberate violation of the law, fraud or conspiracy, intentional violation of due process, deliberate disregard of material facts, judicial acts without jurisdiction or blocking of a lawful conclusion of a case. And if this editor or this guy that wrote this was a judge, he would definitely be deliberately disregarding the facts, because there is no merely disagreeing or mistake of opinion that is going to allow a judge to go to basically be in front of a jury and to be sued. So I mean, this is the kind of reporting that we get from the media nowadays, and I just think that it's the right time to kind of point that out on this show. So hopefully the Des Moines Register, when that Judicial Accountability Initiative law becomes a force here in Iowa, when we start pumping the effort to also enact those provisions, they will also be able to get it right instead of get it wrong. But if they tend to do what they've been doing in the past, they might have a judge write the same sort of opinion for them and have the same sort of article go out and for the public. But we'll be there to correct it. You trust and believe. I wanted to also go back to the point that Ron made, that the guy that wrote the article, David Terrance, was just like the judges he advises, for he cannot deal with the real issues before him. I've seen this countless times, and I thought it was just proper to also bring this issue up here as it concerns a current case that was just before the Iowa Supreme Court, because a lot of times the judges, they just really just don't deal with the issues that's before them. If they want a case to come out a certain way, they won't deal with the real issues before them. They'll just ignore them, or they'll sidetrack them, or they'll just outright duck them, and they'll just dance all around the issue, and next thing you know, the issue becomes ignored, and they have their opinion, and you can, I guess, if you have a problem with it, then they'll just say you just were disagreeing with the opinion. But one of the cases in which this just happened in was the Iowa Supreme Court case. This case was Timothy Reiner versus versus the state of Iowa. This is a post-conviction relief action. The guy basically, this case was filed August 26. You can find this on the Iowa Supreme Court website. Look it up on Google, or you can also go to judicial.state.ia.us. But anyway, this case just filed August 26. Post-conviction relief, for those out there that don't know, is like your last appeal from a criminal conviction in a state. Well, this guy basically, to kind of condense this 8-page case into a nutshell, the guy had basically been arrested back in '95. He was sentenced to prison. He was paroled in '98 for a drug crime, and he was supposed to discharge his parole in October '99. Well, he was arrested in '98 on a second offense while he was on parole, and during that time, his October 16, 1999 date had basically passed for parole, but he was sentenced thereafter on this second offense while he was on parole. Basically, and he brought up the point in his appeal that not only did he have a poor trial counsel who did not try to get his second conviction ran concurrent with the previous sentence in the first conviction, but he also brought to the court's attention that the revocation provisions were not even taken into consideration, and he was not given notice that he could be sentenced. He was going to be sentenced for both the previous conviction and the next conviction, which he got.
That's pretty important to receive notice, isn't it, Terrance?
Yeah, well, the due process clause of the Fourth Amendment in any proceeding involving life, liberty, or property is pretty clear. You know, you're supposed to have a notice and an opportunity to be heard, you know, by a neutral fact finder or neutral decision-making body. But as we see in this case, that's not so paramount here in the state of Iowa.
I suppose if the state doesn't give you notice, that's okay. They can get by with it.
Well, especially when you have a judge or a group of judges that really see that this guy is a criminal, first off, and that first and foremost, we should see to it that he remains in jail as the state wants, because that seems to be the prevailing attitude of a lot of these judges. They're not here to discern what is clearly the law in a lot of instances. What they're doing, and you can see it in case after case after case, if you read all of these opinions, they rarely find that a criminal defendant was wronged, and then reverses conviction altogether. That is something that is so rare nowadays that when it does happen, you'll see it on the front page of the news, because it's like a fluke. So, but did you have any other comment?
Same thing
Don?
applies to the falsely accused.
Yeah, even if you're falsely accused, you could be innocent. Nowadays, they'll make so many excuses, and they'll have so many backdoor reasons why to keep holding the guy, that even if you're innocent, you had DNA evidence. You know, you'll see these cases on TV, and the guy will be in jail for about a year or two before they still release him.
And they absolutely have no evidence to hold the person.
No evidence to hold him. They know he's not done anything. They got the blood sample. They got the DNA. They prove it. They took one test. They had the state take a test. They had the defendant's attorney have a private firm take a DNA test. They tested again. They tested 2 or 3 times. The next thing you know, the guy's still in there for another year before they actually release him.
In where?
And sometimes they still don't release him.
They're trying to keep the prisons full, aren't they?
I really don't understand the rationale. It doesn't make a whole lot of sense here in a free society when we're supposed to be so above the everyday, other civilized societies. We're supposed to be one of the epitomes of civilized society. It doesn't really make a whole lot of sense when you consider it in that context. It just boggles my mind, and I think it should boggle a lot of people's mind. But anyway, back to this guy's story. He was arrested in '95, paroled in '98, was to be released from his parole in '99, but yet before that, on '98, he got a second drug conviction, or a second drug arrest, and then he was convicted after the initial date for his first parole was to be terminated. Well, his whole beef was that he did not have the counsel did not bring up the fact that he did not have notice of revocation of the first parole to be applied to his second conviction. You know, so they basically, when they convicted him the second time, after the fact, they revoked his parole without giving him notice. They said, well, so what? And in this case, they were pointing out, the attorney for this guy basically pointed out that the revocation provisions are supposed to, the parole officer is supposed to inform the sentencing judge that the convicted defendant is a parole violator. And a copy of the commitment order is supposed to accompany the notification. And then there's a second method in which the parole revocation is supposed to occur. And it basically says that the revocation does not actually occur under the statute until the parole judge issues a notice and commitment order. So basically, he received no notice, as this provision is supposed to accompany, which I'm sure this 908.10 was supposed to be in compliance with the 14th Amendment when they wrote it. But as we see here at the conclusion of this opinion, which was done by Judge Cady of the Iowa Supreme Court. And,
yes, I want to hear what the conclusion by the judge is.
Well, the judge basically said in this opinion, or judge is, I'm sure there was other judges that voted on this same opinion here. Reiner claims that the parole officer failed to inform the sentencing judge prior to or during the sentencing hearing that he was a parole violator. He asserts this made his revocation unlawful because it deprived him of an opportunity to have the sentencing judge impose, like I said, concurrent sentences, meaning the sentences are going to be served at the same time for the first offense that he was on parole for and the second offense, which was the new one. But the state responds that there was substantial compliance with the notice requirement because the pre-sentence investigation report informed the sentencing judge that Reiner was a parolee. Well, yeah, but does that actually comply with the notice provisions? I don't know. It doesn't make a whole lot of, it doesn't say anything.
Now, he must have won at the Court of Appeals level because it says the Court of Appeals is vacated.
Well, partially. I think he won partially.
Oh, okay.
At the Court of Appeals. But I've been noticing that the Iowa Supreme Court, whenever they see that the Iowa Court of Appeals has reversed a conviction or done something to help a criminal defendant out in that regard, or not necessarily help them out, but just recognize basic fundamental constitutional rights in a case, they basically come back and they issue an opinion reversing that opinion and basically reinstating the conviction. But anyway, as it respects my initial point, which is that judges are not dealing with the real issues here, as you see in the last two paragraphs of this opinion, they do not deal with the real issues because they say post-conviction relief is a property remedy to seek a review of a revocation of parole. Yet any lack of notice to the sentencing judge concerning the parole violation relates to a defect in the sentencing hearing on the new offense, not a revocation of the parole. Well, yeah, but wasn't he supposed to get notice? They don't deal with it. But anyway, I'll go on. Thus, Reiner's remedy was to raise the issue in a direct appeal from the judgment and sentence on the new offense. Okay, well, that's what he was saying that the attorney should have done. Again, they haven't dealt with the real issue. Section 908.10 requires notice to be given in that proceeding. Okay, that's what the heck he was saying, folks. Any lack of notice to the sentencing judge did not make the statutory revocation under Section 908.10 unlawful. Okay, why not? Where is your explanation? No explanation. And then they go and say, acting like they made an explanation, they say, well, for the same reasons, we reject the due process and ineffective assistance counsel claims by Reiner. The due process claim relates to the failure to provide notice of Reiner's parolee status at the sentencing hearing on the new offense. And the ineffective assistance counsel claim relates to the Federal Council to alert the sentencing court of the opportunity to order the sentence of incarceration for the new offense to be served concurrently with the. Okay, you're stating the obvious here. Where's the rationale for your reasons? It says for the same reasons, but you're sitting there reiterating what his issue was instead of addressing it. All other claims by Reiner, including his double jeopardy claim, either similarly should have been raised or on direct appeal or were not properly preserved for appeal. Okay, that's what he was saying. He was denied an ineffective assistance to counsel claim because they did not raise this issue. So ultimately reject all claims by Reiner. Okay, that's the bulk of their argument, and as you can see, there is no rationale for why he was not to be given notice other than them keep stating the obvious, which was his issue. So prime example, end point of what I was saying, in that they failed to fully address the issues before them. And a prime example of why Iowa also needs a judicial accountability initiative law so we can start suing judges and getting them out of office. And I have another tidbit I'd like to throw out there. Why don't we just do this? Why don't we just throw them out in the first place? Never mind the fact that we can vote them out. We can vote them out under law, but why don't we just throw them out?
What's the word for that?
We would be substantially complying with the law if we just threw them out of office. Everybody just march up to the courthouse, kick the judges right on out. Substantially complied.
There's a
What's good for the goose is good for the gander.
there's a legal statement for kicking them out, just like they do the President of the United States.
I don't know. You got me on that one. I don't know.
Oh,
any
the engineer
terminology
knows
for
that answer.
Okay, the engineer does.
No.
No.
No?
Okay.
What did they tried to do with Clinton?
I don't know.
Your question, you answer it.
Well,
Yeah.
I forgot. That's why I was saying you knew the answer.
Okay.
And
Well,
another two
Impeachment.
Yeah, I knew he
There
knew
you
the
go.
answer.
There you
Yeah.
go. Well, I don't think that provision is in the Iowa Constitution.
Not for judges.
impeaching
No, it's not.
You
Okay.
can vote them out. Well,
Okay.
we can do it and just say that substantially complied with the vote them
Right.
out, right? Vote them
Right.
out law that we do have.
That's right.
But one last tidbit about Judge Katie and this opinion. Definitely, if you have a decision by Judge Katie, you can best believe that it's somewhat shady. And this is definitely a shady opinion, if you ask me.
Okay. Thank you, Terrance. It's good to look into some of those cases just to see where what our judges are thinking. Don, I don't know if we have enough time to look into that case. Why don't we do our best? Here is what it looks like when you see a bunch of cases coming down, juvenile court cases. I think there's 6 of them that came in for report here in August. These take a lot of time, a lot of effort. It means that someone has taken the children away from these parents. And you have one, Don, that is called In the Interest of ZL. And that's Zoe. They want to keep her name quiet, but they mentioned it in the opinion. And just to close down, or just to shorten the amount of time it takes to address this, we'll say that we started on this last week, and we determined that in the early stages, they determined that the mother was homeless. She lived with her mother. So Zoe, her mother, lived with grandma, and that was one reason for removing her. And secondly, she was out of a job. So that means, according to the way I read opinions, that means that if a person is out of a job, we should take their kids, and if they're homeless, we should take their children away from her. Zoe was 4 years old. Why don't you pick it up at that point, and we'll look through this as you read and see if we can find anything substantial that the judges could hang their hat on. Don?
This was filed August 17th of this year. Shelley is the mother of Zoe. Is that Zoe?
Zoe.
Who was born in October 2001. Zoe was born with how do you pronounce that?
I just call it meth.
That's a good way to do it. In her system. Zoe was temporarily removed from Shelley's care until
Shelley.
Shelley's care until Shelley began a substance abuse treatment program later that month. The juvenile court proceedings were subsequently dismissed due to Shelley's voluntary participation in services. And now I'm going to jump to the second page, and it says sufficiency of the evidence. Shelley contends that there is insufficient evidence in the record to justify termination of her parental rights. Shelley admits that she has not yet completed a substance abuse treatment program, but asserts that she should be able to complete a program shortly. She also admits that she had not obtained a mental health evaluation, but states this could be done promptly. Shelley asserts that her home with her mother is adequate for Zoe, and Zoe could be returned to her care.
Now, Don, does that mean that we should remove all children from parents who haven't had a mental health examination? That's what it sounds like to me.
Well, I disagree. Just because you get a professional paid big bucks by the DHS to prove something does not justify termination of parenting rights. Goes on. We determined there is clear and convincing evidence in the record to show Zoe could not be returned safely to Shelley's care. Shelley has not adequately addressed her drug problem or mental health issues from the date of the China, July 15, 2003, until the termination hearing, June 6, 2005. Almost 2 years. Shelley had plenty of time to correct the services required in this case. The parent does not have unlimited amount of time to correct his or her deficiencies. We conclude, what's wrong with a lifetime? The child's still alive. Because we have affirmed the termination of parental rights under this code section, we do not need to address the other code sections.
We made one mistake. We don't have to. Look it over again.
They also terminated the father's rights, but he is not a party to the case.
Wow.
This is
So much for a notice and an opportunity to be heard.
Right.
Shelley claims termination of parental rights is not in Zoe's best interest. Well, that's a mom talking. She asserts the child could be placed with maternal relatives. Not when DHS is involved. They can't. DHS hates that, I think. Because there's no money in it. That's why. John?
No, go ahead. You may have another couple sentences there, and 41 seconds left.
And then the juvenile court could decide not to terminate parental rights based on Section 232.116, Paragraph A. This section provides that the juvenile court need not terminate parental rights if a relative has legal custody of the child. Well, it sounds to me like that they don't want to give a child to a relative, therefore they can't terminate the rights.
That's
Well,
right.
the kid
Isn't that
was
interesting?
the kid was living with the grandmother
Right.
at the same time the mother was living with the
Sure.
grandmother. So it doesn't make a whole lot of sense.
That's right.
They just love to terminate rights. There's money, money, money.
Okay. Thank you for tuning in to the CPI report, and thank you for listening to a few suggestions here. We'll see you next.